Welcome back, America. I'm Hugh Hewitt. Andy McCarthy is, of course, a Fox News contributor, Mr. Go-To on the criminal law, former lead prosecutor of the Blind Shake case, and a longtime prosecutor in the Southern District of New York. Andy, I want to go high constitutional law with you today. You put your con law justice robes on. Hampton Dellinger is the Office of Special Counsel. He is it, or he was. He's been fired, and he's suing. And Team Trump went right to SCOTUS and said, can we get it up to you? Now, I think he's covered under the Myers case, the 1926 9-0 case. You can fire anyone in the executive branch that is a political appointee, and not Humphrey's executor 9-0 case. You can't fire people on the FTC without cause. What do you think?
I agree with that. I also think the administration's spoiling for an opportunity to get Humphrey's executor in front of the court again for its reconsideration. They know that Justice Thomas and Justice Gorsuch have already signaled that they'd be very open to reconsidering Humphrey's executor. In seal of law, I actually hoped that they would reach the question, as those two justices indicated that thought they should have, just so people know what we're talking about. Humphrey's executor is kind of a New Deal era change in what was the settled law. You mentioned the Myers case from the 1920s. The Myers case actually talks about the first Congress back in 1788 or 1789.
89, yeah.
Yeah, where it was basically settled that the president has executive authority, and when you're talking about running the executive branch, exceptions to that rule ought to be narrowly construed. The one in the Constitution is that you require Senate confirmation to seat a certain level of government lawyer or government official, but there's nothing in the Constitution about the president having to get the Senate's or the Congress's consent to remove somebody. The president has to have plenary authority to fire people if the president is to run the executive branch, and all of the executive power in our government is reposed in one official, the president, so he has to be able to remove people.
But the FTC, which was up in Humphrey's executor, and if nothing else, I want a precedent that's easier to say than Humphrey's executor. That case is about removing a Federal Trade Commission commissioner in 1935. And in 9-0, the Hughes court says, nope, you can't do it. It's okay for Congress to set up independent agencies. I've always hated that, Andy, don't you? I mean, it's a mixture. It's a witch's brew of the congressional Article 1 and the executive Article 2 power. I don't like independent agencies.
Yeah, I think it's really the flashpoint, Hugh, of the difference between the originalist vision of the Constitution's framework and the vision of progressive governance, which is that separation of powers is a nuisance. It's okay to accumulate both legislative and police powers and even judicial powers in these supposedly independent agencies, which are, this would be anomalous to the framers. What we mean by independent in this context is they are independent of any branch of the government. Our theory of the Constitution, the framers' theory of the Constitution, was that power, particularly legislative power and executive power, had to be accountable to the people whose lives were affected. So that's the stakes here, and I think it's a very important fight in terms of how we're going to be governed going forward.
So they fired a National Labor Relations Board member. That engages Humphreys. They fired Dellinger. That engages Meyer. I think they want the court to answer this. Do you think the court will do so in the interest of, I'll just say, efficiency and clarity about how the government's supposed to operate?
I would like that, Hugh. If I had to bet, I would bet that this court will be, under John Roberts' steerage, more cautious than that. What they'll say is, look, we don't have to get into these hybrid type agencies that wield different species of constitutional power. What we can say in this case is that the special counsel's office is clearly a part of the executive branch, even if Congress tried to split it off as if it was independent in the 80s. He's clearly an executive officer. They describe themselves as basically the prosecutorial branch of the Merit Systems Protection Board. So
Right.
I think the court can say Trump has to be able to fire him without going to the next question, which is, what about these administrative agencies?
Stand by, Andy. During the break, I want to ask you about my least favorite constitutional precedent and whether there's a prayer of getting it thrown out. It hadn't yet come up for a challenge, but I hope it does. Stay tuned, America. I'm back with Andy McCarthy for a quick 3 minutes. Andy, in the same year Meyer was decided, 1926, the Supreme Court opened the door to zoning in Village of Euclid versus Ambler Realty. I hate that case. I hate zoning. I think it's an uncompensated taking. Do you think the court will ever nudge up against that, if only to push temporary takings or other impositions on people's ability to use their property?
I would have said no even a month ago, but I have to say, after the California fires, which you covered so extensively, they're raising questions that I would not have anticipated would come up, including the conditions that they want to put on people's liberty to rebuild, the coverage issues, and this whole idea of, we're going to rebuild, but we have to have different kinds of housing than existed before, so that we can remake what these communities look like. That's really a bridge further than I thought this would ever go. And sometimes a big crisis like that creates an opportunity for considering things you'd never thought you'd have to consider.
You made my day, because that's why it's forefront me. I did it for 27 years as a land use lawyer. When you were busy getting bad guys, I was trying to get houses built. And I just think what was originally a lot of deference given in the progressive era to the idea of expertise and zoning has just mushroomed, Andy. Like everything else, everything is mushroomed. And go ahead.
I think maybe from about I want to say 1870 until the New Deal era, progressivism was more of a theory.
Correct.
The idea that we could have these altruistic bureaucrats who would just do good and public service. We now have a century of experience with it, and it's got all the downsides of a bad political system, but you're not able to reach the people who are making the decisions because there's no accountability. So as messy as democracy can be, and as much as progressives are repulsed by it in some of its iterations, it's a lot preferable, I think, to the progressive vision of governance.
Well said, and I'm going to play that in hour 3. Andrew C. McCarthy. Follow him over on X at Andrew C. McCarthy. Read him at National Review, where he's the senior editor. See him on Fox, where he's a Fox contributor. Thank you, Andy.
Thanks, Hugh.